Thank you for joining all. My name is Jonathan Levitt from the law firm of Frier Levitt. We'll be presenting today on some issues including that all relate to COVID-19. Some of the issues include business interruption insurance that myself and Michelle Greenberg, my partner of 16 years, are going to be delivering. Also, my partner, co-founding member of the firm, Dan Frier, who started the firm 20 years ago, is going to be presenting on various COVID-related issues that apply to healthcare and life sciences practices with respect to the Paycheck Provider Program, as well as Mr. Maroney, who is a registered nurse and paramedic, one of our many clinician lawyers, who's going to be talking about telemedicine, Medicare advance payments, and governmental enforcement in the age of COVID. So to start out with respect to business interruption, and we're going to try to be very timely because we know everyone has a lot going on, and we're going to try to keep this to 40 minutes. A little quick disclaimer, obviously, we're not giving any legal advice on any of these topics. If you are a client of the firm, you can call us and we can engage directly. This is really for informational purposes only, and we hope to educate the community about these issues, but it's not legal advice. So you've been responsible. You've gotten business, a policy of insurance for your business. You have insurance. You have maybe even business interruption insurance. Well, Ms. Greenberg and I are going to cover what you need to know if you've suffered a substantial reduction in revenue arising from a healthcare or life sciences business that's been closed due to a city, state, or local executive order. Businesses seeking coverage for interruptions that are caused by COVID-19 pandemic should check their policies very, very carefully, as it could be past the recovery, despite what has been a really concerted campaign by, we think, insurance companies to make it seem the opposite, which is that there is no coverage for these claims. There's definitely been a real material attempt in the insurance marketplace to dissuade the public from even filing these claims with their brokers and with their insurance companies. But if you look more closely, there very well could be coverage on these claims. And we're going to go over today how healthcare businesses can look to these policies, what they should be thinking of, and how we can help, frankly. So, Michelle, Ms. Greenberg, there's different types of policies out there. There's, for example, car insurance. There's D&O coverage. There's commercial general liability. What coverage should our clients know about? What's the name of the policy that relates to this type of coverage?
In today's world, especially with the healthcare providers and our life science colleagues, there are a lot of things that they're taking care of right now. And one of the things that they probably shouldn't be spending the majority of their time doing is figuring out what policy do I have, what coverage do I not have. So hopefully today we'll be narrowing that down. And one of the first things you asked is, what is this type of coverage? Your typical auto policy, your liability policy, what we're looking for here and what is going to determine whether or not somebody could recover for their losses is generally contained in what's called a business owner's policy. We'll refer to it as a BOP policy, as well as what's sometimes referred to as an all-risk policy. These are distinguishable from your auto or liability. It's not about somebody who may have caused an accident or been injured on your property. It has to do with your business and your practice and the losses of revenue that you have sustained as a result of what's going to be considered a covered risk. So there are this particular business owner's policy or all risk policy covers your business for losses from fires, floods, and other types of risks that impact your business. And in today's world with COVID and with many of our clients and the providers that are on this webinar, it does have to do with the interruption, the cessation of their practice, their inability to generate revenue that they would have otherwise done, but for the presence of COVID or the executive orders or other civil authorities that have come into play.
Okay, so we have this business owner's policy. In the age of COVID, we all know what we're talking about here. We're talking about potentially a healthcare, life sciences business, a pharmacy, a medical practice, a surgery center that has been literally shut down by operation of the government. What is the name of the category of coverage within a business owner policy that applies here?
So there are a couple, and the ones that I want to focus on would be sometimes referred to as business income or business interruption. There's also civil authority. And then depending on your policy, you may have purchased extra expense or other type of coverage. The business income coverage is exactly what it's entitled. It's the actual loss of business income that you sustain during a specified period of time due to what is routinely used in these insurance policies, a covered cause of loss. In connection with the COVID-19, the related claims are relating to the necessary suspension of your operations, your inability to operate, perform procedures, see your patients, or service your clientele as you normally would, but for this pandemic that we're under. And what is contained in these policies is the requirement that the loss of business income must be caused by direct physical loss or physical damage at the insured property caused by or resulting from a covered cause of loss. That language will be prevalent throughout the insurance policy, whether it's business income, civil authority, or elsewhere. It's basically saying there has to be a physical loss. With regard to civil authority, this coverage applies when a government, a state, a local, the municipality says to you, you can't operate from your insured property. You can't use your property, your premises for what you would normally have been using it for. As with business income, there is still a requirement for what's called physical loss, but this is not the loss at your property, it would be elsewhere. And sometimes it has a mileage requirement where in relation to your property, the mileage, the physical loss has to take place. I know attendees on this webinar from various states, and I'm sure each state has their own orders, executive orders, or other implements that are put into place limiting what can be done. We've seen this with regard to surgery centers, pain practices, not being able to utilize what they insured themselves for, and therefore having sustained a loss.
So Michelle, if I'm a healthcare practice or a pharmacy, surgery center in the United States, any state, and I have had a shutdown because of a governmental order, and I didn't suffer what is a damage to the property. There was my building didn't explode, my healthcare practice didn't catch on fire. So I know you've identified the sort of catch with the business interruption policy. Businesses were interrupted, but you've mentioned there's this requirement for a direct physical loss. If I'm a healthcare practice that hasn't had my property damage destroyed because of COVID, do I have direct physical loss, or should I throw in the towel?
So, and if we'll go to the next slide. Insurance policies are written to cover everything except what's excluded. And that makes it often difficult for individuals reading their insurance policies to determine, is it covered, is it not? When you get a denial letter, do you just rely on it? So there are a lot of coverages, and then there's exclusions. And like I say here, confusion is key, because if your insurance carrier writes you a letter saying, sorry, we're denying your claim, many people won't take it any further. And a lot of it has to do with the confusion in the policy language. These policies, you could get your summary policy, but these policies are hundreds of pages in length, a lot of cross-referencing, so it is confusing. But direct physical loss is one of the key terms that is going to be determined whether or not you have coverage here. And it does not mean that you actually have to be able to see or touch or smell the damage. It doesn't have to be a fire or a flood or something that's cracked in your building. The issue of direct physical loss has been decided by the courts in past, obviously not as it relates to COVID, those have yet to be determined. But generally, courts have concluded that presence of a gas in the premises, or noxious fumes, or other things that you can't see, smell, touch, taste, do satisfy the direct physical loss requirements. And then, as I say, if we keep going, the next thing is, okay, so now there's coverage. What is excluded then? There are, after the SARS and Ebola pandemics, insurance companies took affirmative steps to include virus exclusions. And as sure many people have heard now, if you have a virus exclusion, or the virus isn't a covered cause of loss or isn't a covered claim, check your policy. If you don't have a specific virus exclusion, or if your virus exclusion does not specifically relate to your business owner's claim, don't take the insurance company for for what they're saying. They're issuing denials. The virus exclusions have to be included in order for the insurance company to be able to rely on them. And again, there's other losses or other exclusions, such as bacteria or microorganism, and those are not specific to virus. And it's our position, based on what we've read and what we've seen so far, that the lack of a virus exclusion would be critical to the success of your claim, and certainly gives you a powerful position to take.
So, and just in case any of our attendees bounce off the webinar because they have to for any reason before the end, where we'll go over this in more detail, I just want our folks to know, if you're a Frier Levitt existing client, we will review your policy. Michelle and I will review your policy at no charge to a Frier Levitt client, and just get back to you with whether you have business interruption insurance, do you have a virus exclusion, do you have civil authority coverage? And speaking of civil authority coverage, Mr. Greenberg, what is that? And how does it relate to COVID-19?
So the civil authority, as we said a few minutes ago, is when you are precluded by an order from accessing your property. Your policy covers an insured premises, your business. And when for example, in New York, the executive order, and same in New Jersey, executive orders prohibiting surgical centers from performing elective surgeries, from dermatologists, dentists, plastic surgeons, med spas from performing these elective or non-essential, non-emergent procedures and surgeries. Essentially, the civil authority was telling you couldn't use your property for the purpose of which you insured it. It's, again, these are very novel arguments because COVID is a novel claim, and the insurance companies will take one position, and it might be that they, at the end of the day, don't succeed, but we certainly think that we are in a position to make these claims.
So, Michelle, we talked about physical loss in the context of the business interruption policy, and now you're talking about civil authority coverage. Does this concept of physical loss also apply in the context of civil authority coverage? And if so, how does that work?
It does. The policies that we've seen, and which many are generic with some providers, does still require that physical loss, but it's not physical loss at your property. And the arguments that that would be made is that it's not just, again, like I said, with the fumes or the odors. This is the loss of your property, the physical loss of the use. And in many of these insurance policies, and because wording is critical in reviewing these claims, it's loss of. Mm-hmm. So these are certainly the arguments that have been made in other types of cases, and that will be made in the pending litigation.
And I think it's very important to emphasize that point, that these are contract cases. It's not a case about a statute, a regulation, or a guidance, or interpreting something that Congress or a state legislature did. This is a contract case. Your insurance policy is a contract, and the insurance carrier defines the terms. And there's a lot of ambiguity here. This is where Michelle and I have been trying cases together for 16 years. This is where we have the ability to advocate on behalf of our healthcare and life sciences clients. So, Michelle, we talked about sort of what's covered in an insurance policy, but you also mentioned a couple of times the concept of an exclusion from coverage. You mentioned virus. Tell us about exclusions.
So generally, like we were saying, the inclusion in a policy is what's covered, and then the exclusion is everything that they're going to say is excluded. Most notably in connection with COVID, if you have a virus exclusion, the insurance company is certainly going to hang their hat on it. But they're also going to try and say that bacteria, microorganisms, fungi, whatever words they can come up with to try to basically dissuade people from thinking or fighting for their coverage. Exclusions can be general, but there can also be very specific ones. Again, here, the virus exclusion being the most notable, and without a either incorporated or standalone virus exclusion, we think it's going to be a tough time for the insurance companies.
So if we review a client's policy and it has a clear virus exclusion, would we take on that case for the client?
It's going to be a very difficult case to take on. I think it would be an overall review of the losses and maybe just even some particulars to that particular client. But taking the amount of time and the big defense that will be on the insurance side, virus exclusions are going to be difficult to overcome.
So if we have a client who has a business owner's policy, they have either business interruption or civil authority coverage, and they do not have a virus exclusion, is that the kind of case that the firm would consider taking on?
Yes.
Okay. Now, Michelle, how do courts decide these types of cases? How do they interpret what these policies all mean?
Right. So as you said before, these are contracts, and these are written by insurance companies, sometimes referred to as contracts of adhesion, where the insured, the doctor, the life science provider doesn't have the ability to negotiate. And so courts are very, very strict in construing these contracts. Not every word or phrase is a defined term. A defined term in your policy would normally be capitalized or in quotes so that you know that it has a specific meaning. And in regard to going back to the physical loss, that often is not a defined term. Where it is not defined, we certainly also have a good argument to make that that there's ambiguity. When there's ambiguity, the courts are going to interpret it in favor of the insured, not the insurer, not the insurance company, because they wrote it. And when it comes to coverage, courts want to provide and find coverage wherever they can. They're not going to overread the policies, but they are going to give the plain and ordinary meaning to terms that might be ambiguous. And when it comes to exclusions, they're going to very narrowly apply those exclusions. Courts will take the facts into consideration. They will try to find coverage where the policy language and the facts fit into the puzzle. But if there is an exclusion that likewise has a defined meaning or fits into the fact situation, then they are going to apply that as well. The courts are not there to rewrite a better contract for the parties, but they're also there to protect the insureds who don't have a say in how policies are drafted.
Michelle, what can our clients do to protect their rights with respect to these types of insurance claims for a COVID-related loss?
So one of the first things and one of the most important things right now is making a claim. If you've already made a claim, you've likely received a very quick denial. We've found that insurance companies are just knee-jerking these denials without doing the proper investigation that they would normally do in a non-COVID era. Basically, you have notice requirements in your policy. You have to provide your carrier, your insurance company, with notice that you feel you have a claim. It's our opinion that the claims that you make should be generally stated as opposed to giving too many specifics. Let the insurance company tell you why your claim isn't covered as opposed to you telling them why it should be. The denial letters that you'll likely get are going to have specific citations to parts of your policies, and perhaps there's part of your policy that they overlook or that they don't want to point out that actually does provide you with coverage. In order to make the claim, it would be just a simple letter, and you should start gathering the proofs that you're going to have to submit. Besides getting your policy, get your financial backup, get proof of when and why you ceased operating or practicing. have available the basis for why, such as an executive order. Start estimating your losses, and did you also incur extra expense in having to, in connection with this loss? And just an example would be if you had, for example, with surgery centers, if you had medications that that expired. Well, that's an additional loss. Now you have to go out and buy new medication. So don't, and finally, don't be convinced that it's going to be a waste of time, and don't think that just because you either got a denial letter or your broker said to you, no, don't do it. Just, take the time, send the claim in, and let's see where it goes.
Thank you, Michelle. Final question for you. Are we going to charge our clients to review these policies and let them know what these policies say?
No, at this point, because of the in-depth and the confusion that could be, to somebody who just isn't familiar with reading policies, we're offering complimentary review of policies. Our goal is to take on cases where we know that our clients, sustain significant losses to no fault of their own. We're not looking for people who, might say, well, nobody at my office was infected, or, I didn't have COVID hanging around. If you had to stop practicing, if you were limited in your practice, if you sustain losses, we want to help you. We want to take the view that we know what to look for in policies and let you know, listen, we think you have a good claim, or, unfortunately, it doesn't seem like this is a claim we can help you with.
Thank you, Michelle, very much. Mr. Maroney, I believe you're up next to talk about your COVID-related telehealth and some regulatory issues.
Good afternoon, everybody, and thank you for joining. I'll be pretty brief. Let's just speak for a couple of minutes about telemedicine and the benefits of telemedicine. Many of you, because of the COVID-19 pandemic, may have already engaged telemedicine. So telemedicine is a modality that has been around for quite some time, that we have been promoting, and Frier Levitt has been working with clients, from physicians to telemedicine providers, to the people developing the modalities, and extending it beyond just the non-face-to-face encounter, but remote patient monitoring and some other modalities. COVID-19 has really caused telemedicine to expand exponentially. People are confined at home. There's concern with travel. There's concern with exposure. There's concern with availability of PPE. And physicians and other providers can provide a non-face-to-face encounter via technology platform. Now, there's been a number of waivers that have occurred as a result of COVID-19 that has helped accelerate telemedicine. Prior to the COVID-19 pandemic, there were a number of limitations to telemedicine, primarily coming from Board of Medicine rules, certain state laws, and insurance providers' reimbursement methodologies. So some of those waivers are that a physician-patient relationship can now be established via telemedicine, as opposed to having to establish it in an initial face-to-face encounter. Also, insurance companies have embraced reimbursement more. Medicare, for example, now reimburses for telehealth encounter, and has even lessened the requirement for technology to reimbursing for telephone encounters with patients. Prior to the COVID-19 waivers, Medicare did not reimburse for a telehealth encounter if the patient was in an originating site that wasn't a healthcare facility, which meant you couldn't use telemedicine to access a patient at their home. So, going forward, we believe that even after the pandemic, many of these waivers will become permanent solutions, permanent reimbursement methodologies, and that telemedicine will remain a significant part of the healthcare landscape, and that providers should be prepared to continue to use telemedicine for at least a portion of their practice. I mean, it's never going, telemedicine will never replace face-to-face encounters, and it is limited by the fact that the practitioner can't lay hands on the patient, which leads to one of the admonitions that we need to make, is that even when engaging in a telemedicine encounter, licensees are still bound to the standard of care. So, for example, if you needed to listen to a patient's lungs or take their blood pressure or palpate a portion of their body to make the diagnosis, and you can't do that via telemedicine, you may not be able to make that diagnosis. One of the other important waivers, particularly for those in the pain management community, is that the DEA has issued a waiver that opiates and Schedule II narcotics can be ordered via telemedicine. So there's really a broad expansion of telemedicine. On the downside, or is that many people have started doing telemedicine and may not be getting reimbursed, or may not not understanding how to bill correctly. So it is important that that you understand how to bill, what the proper codes are. There are also waivers as far as copay. So you need to check with the patient's insurance company. And one very important factor is to as with all other areas of healthcare, is appropriate documentation. Because when it comes to billing and collection, particularly in this environment, particularly in telehealth, when you're not face-to-face with the patient, you have to make sure that you have the appropriate contemporaneous medical records prepared so that you can support your documentation. There are a number of educational memoranda put out by CMS on how to bill correctly for telemedicine when billing Medicare beneficiaries. And so we want you to be aware of that. And we can provide support to people in the medical community that have questions about applying telemedicine, utilizing telemedicine. And as we said, it is likely to be here to stay and be a significant part of healthcare in the future. So very briefly, we just wanted to touch upon some of the additional waivers and things that have occurred as part of COVID-19. There's been the Medicare Accelerated Payment Program, which many of you may have participated in. And we just want to remind everybody, and this is not, the Medicare Accelerated Payments are not part of the forgivable loan programs that Dan is going to speak about. Medicare Accelerated Payments are just advanced payments that ultimately are going to be recovered by CMS, and that's going to be recovered from your future payments. So you need to be aware of that, and particularly as the likelihood that revenues will be down in the upcoming months. So that's something to be cognizant of. Also, as I mentioned, with telemedicine, there are copay waivers for things other than telemedicine, such as COVID-19 testing. So please be aware of that. And again, one of the things with any type of copay waiver, you want to make sure that you document and put in your documentation that is COVID-19 related or occurred during the pandemic, so that 6 months or a year from now, when a payer audits you, you will have the requisite documentation to support your waiver of copayment. Again, concentrate on correct coding. As I said, documentation, very important. And the last two things, we handle a great deal of enforcement actions by the federal government and are basically in communications with federal agents almost daily. And the federal government's investigations or traditional fraud investigations have been slowed and focused on COVID-19 related fraud investigations, many involving price gouging and false claim or misleading claims about cures. But those fraud investigations are also turning to claims, reimbursement issues. So you need to be very cognizant of that right now. And then there's clearly going to be post-COVID-19 enforcement actions. Again, you need to protect yourself by again, appropriate coding, appropriate documentation, and focus on these areas that have always been important, but you need to redouble your efforts, because the money that's being paid in many of these programs, the attention to detail by Medicare administrative contractors, by payers, are not there right now. But as we've seen in both healthcare and the life sciences, that payers routinely audit a year, 2 years after claims are paid, and the documentation is the only thing that stands between you and recoupment. Thank you.
Hi, everyone. Thank you for your patience and for participating in this. I'm going to talk fairly briefly about the PPP loan forgiveness process. This is not a deep dive. We don't have time. I did a webinar previously on a really deep dive into the PPP loan forgiveness process, and we just don't have time for that now. But what I thought I'd focus on are some little tidbits of information that have come out over the last several weeks in the form of FAQs, as well as the new application for forgiveness, which came out, which any of you who have a PPP loan should have received already, and it provides a lot of information. So I'm going to be going over literally just random additional little tidbits of information. I'm going to try to answer some of the questions that were posed before today's webinar. I'm not going to get to all of them, and I apologize in advance. And I'm going to just start with this first one, which is pretty straightforward. And this is based upon the FAQs. A lot of questions about when does the 8-week loan period begin, and it begins with the disbursement of the PPP loan money. So the minute you receive that money, not when you sign the promissory note, but the minute you receive that money, that's when the 8-week loan period begins. And it's during that 8-week period which you will use the loan proceeds, and the amount of forgiveness is going to be based upon how much of those loan proceeds you used and how you use them. You all know about the 75%, 25% rule. 75% has to be payroll. 25% can be the non-payroll expenses such as rent, utilities, and mortgage expenses. Most of you will not have mortgage expenses, since unless you operate a business that also owns a piece of real estate, which is usually not the case, which is why it's typically either mortgage or rent, not both together. What if the assets of your practice business were recently sold? This is not going to apply to that many of you, but it may apply to some, and it's an interesting clarification of the law. And the best way to summarize it is, if you recently sold your practice, let's say, and you are now in a situation where you, let's say the practice was sold, and the closing hasn't taken place yet, but you applied for the PPP loan, you can wait to apply for the PPP loan, and the acquiring entity can apply for the PPP loan using your employees and your payroll information, even though it's not under the same tax ID number. If you applied for the PPP loan previously, then the law isn't that clear in terms of how to deal with it. But to me, this FAQ response indicates that the intent is that SBA understands that even if your business isn't around anymore, it nevertheless is being subsumed by another company, and that new company should get full credit for maintaining your employees. What if an employee refuses to return to work? So this is an interesting question because I've had numerous clients prior to this FAQ coming out. We furloughed an employee, we got the PPP loan, and now we're inviting the employee to come back, and the employee doesn't want to come back, either because they get more money through unemployment or because they have young children at home and they can't work and they need to be home, and they can't work at home and they can't come to the office. And so this FAQ provides guidance that if you have made an offer to an employee for the same work level and the same compensation, and they refuse to come back, you can still get full credit for that employee. Now, and they also add an interesting caveat, which is that employee may not be eligible for unemployment if they refuse employment. If they refuse employment, then in most cases, they will not be eligible for unemployment unless they meet some exception in state unemployment rules. That may be a way to incentivize employees to come back. But one of the areas that the FAQ doesn't really fully address is you only get forgiveness based upon the amount of the loan that you spend. So if you have 3 employees that refuse to come back, you're not spending money on their compensation during that period. The way I interpret this FAQ is it will be treated as if you spent that money, and you will also not be penalized based upon having a fewer number of FTEs. As I look at it, you get both benefits, and I think that's the appropriate interpretation. But if there's additional guidance, we'll obviously keep our mailing list aware of that. Interestingly, if you go to the next slide, Katie, this is directly from the application. The FAQ says one thing, but the application adds some additional caveats. If you terminate an employee for cause, if the employee voluntarily resigned, and as we said before, if the employee voluntarily requested and received a reduction of their hours, right? You have an employee that says, I have young children, they're out of school, that I can't send to daycare, so I need to be home now, I can't work as many hours. Under all those circumstances in the application itself, those individuals will not be counted against you. Okay, this is a huge clarification, very important clarification. So that may impact the way that you handle employees, the way that you may even, have a situation where you're not sure you want to keep an employee and the employee is not sure they want to stay. Certainly, it'd be better if the employee voluntarily left than if you terminate them under those circumstances. Next slide, please. What is meant by the average number of FTE employees? So the average number of FTE employees during the forgiveness period affects how much forgiveness your business is entitled to. If you go below the previous average that you've chosen, the previous applicable average, then you're going to receive a pro rata reduction in the amount of forgiveness. But there's been a lot of questions in the past. What is the average number of FTEs? How do you calculate that? The first thing I want to mention is I've always counseled, and I continue to counsel all my clients, that the way you calculate the average number of FTEs during the forgiveness period should be the same exact methodology that you use to calculate the prior measurement period. There's a 2019 measurement period and there's a 2020 measurement period. You need to be consistent with both of those. And I think that's the most important thing. So what they've now clarified is that there's 2 methodologies, essentially. For each employee, you enter the average number of hours paid per week and divide it by 40. And then round the total to the nearest 10th. And the maximum number, so no longer are so they've clarified that you can't use a 30-hour work week. So for example, you can't say to your employee, we're going to reduce your hours from 40 to 30 hours, and you'll still be 1 FTE. That would potentially present a problem under this guidance, because now they no longer work 40 hours. The other piece of guidance that's clarified by the FAQ is that the maximum amount of each employee is capped at 1. I have had clients in the past say, well, what if I have employees who work overtime, more than 40 hours a week? They count as 1. You can't count them more than 1. they've also indicated in the FAQ that you can use a simplified method that assigns 1.0 for employees that work 40 hours or more, or 0.5 for employees who work fewer hours. Obviously, you're going to use whichever of these methodologies works out best for you. Again, it should be consistent both during the measurement period, prior to the loan, and during the forgiveness period. Next slide, please. So there's an interesting safe harbor that people don't understand. It's in the actual law. And it basically says that if the borrower, I'm going to read it because I just think it's easier to just read this particular thing. Specifically, the borrower is exempt from the reduction in loan forgiveness based upon FTE employees if both of the following conditions are met. One, the borrower reduced its FTE employee levels in the period beginning February 15 and ending April 26, 2020. And also, the borrower then restored its FTE employee levels by not later than June 30, 2020 to its FTE employment levels in the borrower's pay period that included February 15, 2020. So the pay period would be like whatever period, if you pay every 2 weeks, it would be a 2-week period that the date February 15 is part of. So this is how I interpret this. And this is one of the more complicated parts of the law. As I mentioned before, there are 2 measurement periods. One is in 2019, one is in 2020, and you can choose either one of them. You're obviously going to choose the one that has the lowest number of FTE employees because that's the comparison you're going to make with the 8-week period you're in. So if you have 20 FTE employees in 2019 and you have 25 in the 2020 period, you're going to use the 2019 measurement period and use 20 full-time employees as the comparison. If you drop down during this period between February 15 and April 26th, during that period, any point in time, you drop down below that 20 employee level, you're going to, without this exception, and some folks have referenced this as taking a mulligan, like on a golf shot. If you didn't have this mulligan, then you'd be stuck. That reduction would cause you to have a reduction in forgiveness. But as long as you restore the number of FTE employees by June 30th to their full-time employee levels that they were on February 15th, which is likely a date that it's a date that preceded any of the shutdowns, any of the lockdowns, then you get essentially a mulligan, even if your employee levels are still lower than what they were during the 2019 era period. So I'm not going to be able to explain this in probably enough detail for all of you to understand this because it's rather complex and I need to work on this explanation perhaps, but suffice it to say that you get to take a mulligan and compare, as long as you restore your employees by June 30th, you'll be compared to where they were on February 15th. And as long as they're comparable, you're okay. Next slide, please. That was my last slide. Okay, so now what I want to just do is, we did get a couple questions. I'll try to go through a couple of them real quickly. I'm going to make a statement and then I'm going to explain it. The law from the very beginning made it clear that the expenses you can include during that 8-week payment period are expenses that are incurred and paid. Okay, so what does that mean? It effectively means that we're talking about cash basis payment. If you can't prepay, for example, you can't prepay expenses because those expenses, even if you pay them during that period, have not been incurred during this period. So what most accountants that I've spoken to have interpreted this to mean is that the expense has to have been incurred and has to have been paid during that 8-week period. Now, a lot of folks have asked, what about if I want to give if I want to increase the compensation of my employees during that period of time? My response is this: you cannot prepay employee compensation or bonuses, but there's no reason you can't. I have not seen any guidance that says you cannot increase the compensation of employees, particularly since now they're working under harsh conditions, right? They're risking themselves during this crisis. They may be working more hours. They may be working in a harder because there are fewer employees available. So increasing compensation to me during that period is a legitimate payroll expense if that's the route you choose to take. Again, you cannot prepay though. Now, one of the things that also comes up with the prepayment is, how do I work my payroll? Okay, so let's say that I get the loan money in the middle of a payroll session. Well, you're going to use that part of the payroll that is included within the 8 weeks. You're not going to use that part of the payroll that was included in another part of the 8 weeks. I've also received a question. Well, what if I receive the money mid-month? I've already paid rent that month, and I'm only going to get. It might depending on how the timing works. It might impact the number of times I pay my rent. It shouldn't, in most cases, impact the time, but a strict reading of this is that you're only going to get credit for what you pay. However, you should speak with your attorney or your accountant, because there may be some wiggle room in terms of when you pay that rent. There's nothing that says in your lease documents that you can't pay a month's rent before the first of the month. That's not necessarily a prepayment in the same way that if you were to prepay like 3 or 4 months of rent. So now most of my clients are not struggling to figure out how they can pay more non-payroll expenses. They already have that covered. Most of my clients are struggling to figure out how they can pay more payroll expenses so they get the 75%. That's the key. As you all know, anything you don't use will turn into a loan, with the caveat that I believe if you have an employee that you've offered employment back and they don't come, I think that I believe their compensation can be included in the amounts as if you had spent them towards the loan. That's a significant takeaway from the recent FAQs. Okay.
Dan, I was just going to jump in if I can, because I did see one important question come up that I want to make very clear with regard to the insurance part of this seminar.
Sure.
A question was asked whether or not they should a practice should wait to file a claim until they can calculate or determine the extent of their losses. And the answer to that is absolutely not. Don't wait. Your insurance policy has notice requirements, and the longer you delay, the greater your risk of having your claim be denied on a timeliness basis. As I stated earlier, make a general, broad type of claim, a simple letter stating, I am intending to make a claim. I have losses and damages resulting from my interruption of my business. I am putting you on notice that I want to make a claim. And then back into it, but don't wait, because you don't want to find out later on that you waited too long to put your carrier on notice.
Okay. As I mentioned, we're getting a lot of good questions about PPP loan and about the insurance issues. We're not going to have time to answer them at this point, but you can submit your questions. And if there's something that we can answer very simply, happy to answer them. If not, we can schedule some sort of a phone call. Anyway, thank you for your time.
Thank you, everybody. And thank you to obviously all the healthcare workers on the front lines. We appreciate all that you guys do. Thank you.